Morning, folks. My name is Kurt Hitzemann, County Court Judge here in Hernando County. You folks are here for your first appearance. The purpose of the first appearance is so that you may be informed of the charges against you. I'll determine if there's probable cause for those charges. Probable cause simply means that it's more likely than not that a crime has occurred, and more likely than not that you're the person who committed the crime. Of course, as you stand before me this morning, I presume that you're innocent. That presumption of innocence will stay with you through each and every stage of the proceedings unless and until the State Attorney's Office can prove the allegations against you beyond and to the exclusion of a reasonable doubt. We'll set your conditions of pretrial release, that is your bail or your bond. In most cases, your bond has been set already pursuant to the bond schedule here in the 5th Judicial Circuit or the warrant which led to your arrest. I'll determine if that bond should be raised or lowered or left the same, or whether there'll be additional conditions of pretrial release placed upon you. We'll let you know when your next court date will be, and if you'd like to have the services of the public defender, I'll gladly appoint the PD to represent you this morning. You do have a right to have contact with folks on the outside, family, friends, counsel. If you haven't had a chance to make that call, please let me know. We'll make sure that that happens. Finally, and most importantly, you're advised that you do have an absolute right to remain silent with regard to the facts which surround your arrest. I encourage you to do that. These proceedings are recorded. In addition, there are 2 assistant state attorneys in the courtroom with me this morning. If you say something that tends to incriminate you, they will use it against you in the prosecution down the road. I now need each and every one of you there at the jail to please raise your right hands and be sworn. Y'all solemnly swear or affirm, tell truth, whole truth, none but the truth. Very good. When I call your name, please step forward to the podium. Stacy Fiandola. Want to, Stacy, what's your date of birth?
3/8/83.
Stacy charges trespass. There's probable cause for the charge. As to that charge, you wish to represent yourself. You're going to hire private counsel. Would you like me to appoint the public defender?
Public defender.
I'll appoint the PD. Ms. Preston, what can you tell me?
Yes, sir. On July 16th, there was a Hernando County charge of fraud. It's listed as fraud, swindle, hire, vehicle with intent to defraud, and a petty theft adjudication. I also see the charge of another fraud, uttering a false bill. Okay. Drug possession, guilty, July 2016 arrest, and then a battery case that was not prosecutable actually in 2005.
Okay. And Stacy, where you been living lately?
What's that?
Where do you live?
With a friend.
Okay. Does a friend have an address?
Yeah, I don't know it off the top of my head, though.
Okay. You have a job these days?
No.
Are you on probation right now?
No.
Okay. I'll leave the bond at $1,000. I'm going to have you back in court on September 13th. If you get out, make sure you go see the public defender right away, all right?
All right.
Thank you. Mitchell Fowler. Want to, sir, what's your date of birth?
5/15/81.
All right. Which I have, first thing I have for you is a warrant signed by Judge Toner. He found probable cause for 4 counts. Count 1 is lewd lascivious molestation on a victim between 12 and 16. Count 2 is lewd lascivious molestation on a victim under 12. Count 3 is lewd and lascivious conduct with a victim over 12. And count 4 is show obscene material to a minor. As to those charges, you want to represent yourself, you want to hire private counsel, would you like the public defender?
Public defender.
I'll appoint the PD. State what you tell me.
Besides the FTA that you're aware of on charges and
Yeah, you guys get 2 of them. We'll get to those in a second.
Yeah. We have 2016 possession of a controlled substance. Let's see, possession of marijuana 2016, possession of paraphernalia 2015, and then in the great state of Texas we have theft 2004, another theft in 2004, and just for fun, 2 more of those in 2004.
All right. And Mitchell, I don't have an address for you. Where have you been staying lately?
Different friends' houses.
Okay. Do you have an address?
No, sir.
Okay. Do you have a job?
Not now.
Okay. All On count one, I will set your bond at $10,000. On count two, at $50,000. Count 3 and 4 at $5,000 each. That's a total of $70,000. Condition to your bonds is that you have no contact with any alleged victim. You have no contact with any human being under the age of 18. No contact means no contact of any kind. You don't call, you don't write, you don't email, you don't text message, you don't contact through social media. You don't have a third person contact. You don't go where the victims live or go to school. You don't go where any people under 18 might congregate. You don't have any contact of any kind, any way that you might imagine having contact. I forbid you to do that. Any sort of contact whatsoever would result in all of your bonds being revoked and you being held without bond. If you're able to bond out, you'll also be subject to GPS monitoring at your expense. Those charges will all be back on the 19th of September. If you don't bond out, the public defender will come see you in the jail before your court dates. The other issue I had for you, Mitchell, there's 2 warrants for FTA. One of them was signed by me, the other by Judge Rupie. I'll go ahead and appoint the public defender on those. Those are going to come back. The bonds are $2,000 each on those, and those will come back on September 6th. Public defender will come see you before court on those misdemeanor charges as well. All right? Thank you.
Excuse, Your Honor.
Yes, you may.
Thank you.
Have a nice day, Joe. See you. Arnie Collins. Morning, sir. What's your date of birth?
8869.
All right. Arnie, you're hearing a warrant signed by Judge Toner. He found probable cause for a violation of probation. As to that charge, you want to represent yourself, you want to hire private counsel, would you like the public defender? I'll appoint the PD. Bond on the warrant is no bond. I can't change that. I'm going to change your date. I'll send you back to see Judge Toner on the 11th of September. Public defender will come see you before then, okay?
Yes, sir.
Thank you. Brent Courtney. Morning, Brent. What's your date of birth?
11/27/1991.
All right, Brent, this morning I have a warrant signed by Judge Neal. He found probable cause for 4 counts, robbery with a deadly weapon, ag assault with a deadly weapon, ag battery, great bodily harm, and false imprisonment. As to those charges, you want to represent yourself, you want to hire private counsel, would you like the public defender?
Public defender.
Appoint the PD, state.
Judge, the history starts out with criminal registration out of Pasco 2011. 2012 issues a parole violation. FTA in 9/2013 out of Fernando on a charge. I have a grand theft 2014. I have another criminal registration in February 2014. I have a BOP out of February 2015. I also have a misdemeanor battery. August 2015, I have tampering with a witness, and I served Florida State Prison on that sentence. I show another battery out of 2016, Hillsborough County. Show a BOP out of Fernando County in March of 2016. I show another Florida State reception, May 2016 registration. BOP in December 2016 out of Fernando. Then 2017, a resisting and arrest on our warrant, February 2017 out of Pasco. And he had a misdemeanor resisting here. And I think that's where we are. Judge.
Okay. And Brent, the last address I have for you is on New Hope in Spring Hill. Is that where you're living?
Yes, sir.
How long you been there?
4 years.
Do you have a job these days?
Not now to incarceration.
Okay.
Just, sorry to interrupt. There is extensive history out of state as well.
Yeah, I'm familiar with Brent. Okay, I'm going to leave the warrants, Brent, per Judge Neal's, the bonds per his warrant. which is $50,000 on count 1, $2,000 on count 2, and $5,000 on 3 and 4. That's a total of $62,000. Condition is that you'll have no contact with any alleged victim. We'll have all these charges back on the 19th of September. If you're able to bond out, very important that you go see the public defender. If you can't, they're going to come see you in the jail before court, all right?
I have one question.
Sure.
Who's the alleged victims? I know not to have contact.
I've got the alleged victim on count 1 is Jaron Allen. Count 2 is Jaron Allen. Count 3 is Jaron Allen. Count 4 is Jaron Allen. All right, thank you.
All right. Thank you, sir.
Yep. John DeMasi.
Morning, y'all.
Morning, sir. What's your date of birth?
5/20/77.
All right, John, you're here on a warrant that was signed by Judge Rupie. Apparently, you failed to appear in her court on a notice to appear for a violation of probation. Ms. Newby, is there a recommendation for this gentleman?
30 days.
All right. John, the recommendation on the VOP is 30 days in the county jail. You can accept that this morning if you wish. If you don't want to do that and you'd rather speak to a lawyer first, you certainly can do that. You want to take the 30 days, you want to talk to a lawyer first.
I'd like to talk to a lawyer.
All right.
There was a good reason behind it.
Okay. And you want the public defender?
Yes, please.
All right, I'll appoint the public defender. Let's see. This is Judge Rupie's. The bond is going to stay no bond. I'll have you back in court, however, we'll make it the 29th of August. Public defender will come see you and see if there's something that they can do other than the 30 days, okay? Thank you.
Okay.
Is 829 Judge Ruby?
Yeah, it's her arraignment thing.
Yes, sir. Thank you.
Yep. Ralph Outland.
Morning, Your Honor.
Morning, Ralph. What's your date of birth?
July 10th, 1987.
All right, Ralph, I got a warrant for you out of Citrus County. The judge that signed the warrant found probable cause for some charge relating to an abandoned or derelict vessel. And then set your bond at $500. I can't change that bond, Ralph. If you can post that bond, then you'll get out of jail here and go up to Inverness and find out when they want you back in court. If you can't post that bond, we'll notify Citrus right away. I would give them 5 days to come get you. It doesn't take 5 days with Citrus, but if for some strange reason you were still here 5 days from now, they'd bring you back to see me, and I'd find out what the holdup is, all right?
Okay, will I be appointed a public defender from you, or will I get
Yeah,
one from you?
you'll do that when you get to Citrus, John. I can't appoint you one here because your charge is up in Citrus.
I'm not John, sir.
Say it again?
I'm not John, sir. You said you'll do that, John? I'm Ralph, sir.
Okay, I'm sorry. Okay, Ralph, I can't appoint you a public defender here because the charge is in Citrus County.
Okay, thank you, sir.
Thank you.
Yes, sir. You said bond remaining at 500?
Yes, I did.
Okay, thank you.
Anthony Pace. Morning, Anthony. Date of birth?
1181.
Okay, and this is a transport on a BOP. Okay, Anthony, did you want the public defender?
Yes, please.
All right, I'll appoint the public defender to represent you. Looks like you're coming back on the 28th of August in front of Judge Toner. PD will come see you before then, all right?
Thank you, sir.
Thank you. Daryl Thomas. Morning, Mr. Thomas. Date of birth?
Good morning. 5/27/88.
All right. Mr. Thomas, you're here on a warrant signed by Judge Toner. He found probable cause for violation of probation. As to that charge, you want to represent yourself? You want to hire private counsel? Would you like me to appoint the public defender?
Defender.
I'll appoint the PD. Bond on the warrant is no bond. I can't change that. I'm going to change your date. They told you the 19th. I'll have you back on September 11th, and the public defender will come see you before then, okay?
Yes, sir. Can I ask you a question?
Sure can.
They have it as a felony violation, but I was on misdemeanor probation.
It's a misdemeanor charge you were on probation for, Daryl. There's no doubt about that. It just happened as part of a felony case. So the case apparently started out as a felony. They put you on probation for a misdemeanor, but you still go back to the felony judge to deal with it, all right?
Okay, sir.
All right, thank you. Hein Tran? She told me it was
Yes, John.
Morning, sir. What's your date of birth?
10/27/69.
All right, sir. You're also here on a warrant. This one was signed by Judge Merritt. He found probable cause for violation of probation. As to that charge, you want to represent yourself. You want to hire private counsel. Would you like me to appoint the public defender?
Yes, John.
I'll appoint the PD. Bond, of course, is no bond. I can't change that. I'll send you back to see Judge Merritt on September 19th, and the public defender will come see you at the jail before then, all right?
Yes, John.
Thank you. Fidel Valley? Morning, sir. What's your date of birth?
2/26/85.
Fidel, you're here on a warrant signed by Judge Merritt. He found probable cause for a violation of probation. As to that charge, you want to represent yourself. You want to hire private counsel. Would you like the public defender?
PD.
I'll appoint the PD. Bond on the warrant is no bond. I can't change that. I'm going to change the date. I'll have you back in court on September 11th. Public defender will come see you before then, okay?
Thank you.
Samuel Whaley?
Morning.
Morning, Sam. What's your date of birth?
9/4/79.
Sam, you're here on a warrant signed by Judge Toner. He found probable cause for violation of probation. As to that charge, you want to represent yourself. You want to hire private counsel. Would you like the public defender?
Public defender.
I'll appoint the PD. Bond on the warrant, of course, is no bond. I can't change that. We'll change your date to September 11th. Public defender will come see you before then, okay?
Thank you.
Thank you. Nicholas Courtwright? Morning, Nicholas. What's your date of birth?
12/25/78, sir.
All right, Nicholas, you're here on a warrant that it appears that I signed. Apparently, you failed to appear in my court on 2 counts: possession of marijuana, possession of paraphernalia. Did you have a lawyer on those cases?
I believe public defender
Yeah,
was
the
appointed. I was supposed
I
to
thought he
meet with
waived.
Shelley, my bondswoman. She's going to meet me up there this morning, but I got arrested last night instead. She said that she carried my bond, or I have epilepsy and I have seizures, and I'm sorry I missed court, sir, and it won't happen again.
Okay. Do you have any history, Steve?
Yes, extensive. There's 51 pages.
Okay.
But it is possession of cannabis and paraphernalia. I'm trying to take in consideration what he actually did.
Right.
It was a minor amount of cannabis. He did admit ownership. We're making an offer today at first appearance only of 30 days.
Okay.
And Judge, he had 3 days previously on it.
Okay. Nicholas, if you wanted to resolve it today, 30 days in the county jail would get it done. You've got credit right now for 4 days in. Means you'd have about 3 weeks left to do. If you'd rather have a chance to speak to a lawyer first, then I'm going to leave the bonds at the $2,000 on each count. It would be a total of $4,000, and then you'd be back in court on the 6th of September. So you want to take the 30 days, or you want to try to bond out, or speak to a lawyer?
You take 30 days.
You understand by entering a plea in this case, you give up the right to have a trial by jury, the right to confront the witnesses against you, the right to remain silent, the right to have a lawyer represent you, but you want to give up those rights so we can resolve this case today? Yes?
Can I ask you a question? Is Miss Shelley there, the bondswoman? You wouldn't let her restate the bond again?
It wouldn't matter if she was here. The offer would be the same. You're not being charged with failing to appear, and based on what you've told me, you're not likely to be charged with failing to appear, but you have been charged with possession of marijuana and possession of paraphernalia. And based on the cooperation in those charges and your history, which is extensive, the state has offered 30 days. If the bondsman was here, that's exactly what would be happening. She'd be offering 30 days, and I'd be telling you can take 30 days or you can pay $4,000 to get back out again. So the FDA doesn't mean anything, and it never was going to mean anything. This is just how I get you back on the docket. So if you'd like to take the 30 days, we can do that. If you want to have a chance to speak to a lawyer first, you can do that.
I guess I'll just take the 30 days then.
All right. So you're willing to waive your rights so we can enter this plea today?
Yes.
Case number, let's see, 17 MM2446, as to the charge on count 1 that you possess misdemeanor amount of marijuana. How do you wish to plead? You can plead no contest.
No contest.
As to the charge on count 2 that you possess drug paraphernalia, how do you wish to plead? You can plead no contest.
No contest.
I'll accept those pleas. I'll find they're freely and voluntarily made. I'll adjudicate you guilty on both counts. Sentence you to 30 days in the county jail on both counts with credit for 4 days served on both counts. Those 30 days will be running concurrently or at the same time. There'll be a fine and court cost on count 1 of $533. Additional fine and court costs on count 2 of approximately $90. There'll be your cost of incarceration. But Nicholas, that takes care of it. You just had to finish the time, which I said should be about 3 weeks, all right? Thank you. Be the 1-year deal as well.
That also included the $50 cost prosecution?
Yes, ma'am.
Thank you.
Yep. Joseph Zumbo.
Morning.
Morning, Joe. What's your date of birth?
July 5th, 1985.
All right, Joe. The charge this morning is felony battery by strangulation, and state. It sure looks like that's what happened, but the PC affidavit doesn't contain any words that say airflow was restricted.
Yes, sir. Can we please have 24 hours?
Yeah, what I'll do is, and I'll explain this to him in a second, is I'll set a bond commensurate with the charge as it is, so that if he wants the bond out, he can, and then give you guys 24 hours to confirm that there's PC for it, so I can find PC.
Yes, sir.
So I'll give you 24 hours on PC, but set him a bond as well. So if you can give me a little history. Does he have any criminal history, Kim?
Oh, I'm sorry.
That's all right.
Just one moment. I was writing down what you said.
Yeah.
I don't show any history here. I do show a charge of domestic violence. I think this is out of New Jersey in 2008. It was a domestic violence guilty, it said.
Okay. And Joe, I have an address for you on Wake Robin Drive in Brooksville. Is that where you live?
Yes.
How long have you lived there?
5 years.
And does Crystal live there as well?
Yeah.
Okay. Do you have a job these days?
No.
Okay. All right. So here's what we're going to do. At the moment, there's probable cause for a domestic battery. The charge that you have this morning is felony domestic battery by strangulation, and based on the probable cause affidavit that they gave me, I can't find probable cause for that. I'm going to give, and that's a second-degree felony, so that's as opposed to a first-degree misdemeanor. That's a much more serious crime. It may be that probable cause exists for that charge. This morning, I'm going to set you a bond of $2,500. You can bond out if you wish or if you have that ability, but I'm also going to have the case brought back tomorrow morning. If you have bonded out, that's fine. You can bond out because that won't change your bond or your court date. But then I'll be able to find probable cause for the higher charge for the state if they have that. So if you do bond out, like I said, the court date will stay the same. If you don't bond out, then it's conceivable that I will lower your bond if the state doesn't have probable cause for the felony and only has probable cause for the misdemeanor. If you are able to bond out, you'll not have any contact with Crystal. No contact means no contact of any kind. You don't call, you don't write, you don't email, you don't text message, you don't contact her through social media. Don't have a third person contact her. Don't go where she lives. Don't go where she works. Don't have any contact of any kind. Any way that you might imagine contacting her, I forbid you to do that. If you have contact and we find out about it, your bond for whatever charge would be revoked and you'd be held without bond until that charge was resolved. It means no contact even if she wants the contact. So if you answer your phone and hear her voice, you should hang up. If you're out and about and see her, you should turn around and run the other way. You need to understand that she cannot drop the charge against you. That's not a decision she gets to make. She may go to the state attorney's office and ask them to drop the charge. She may tell them that she's not interested in pursuing this matter, but that decision belongs solely to the assistant state attorney who's handling your case. So unless that person or the judge on your case tells you the charges are dropped, you should assume they are not dropped, and you should not have contact. In addition, today I would hold you up until 4 p.m. so that if she wanted to serve you with a civil injunction for protection against domestic violence, we'd know where to find you. If you get the civil injunction, it's doubly important that you not have contact, because in that case, not only could you get your bond revoked, but you could get new charges for violating the injunction. If you do bond out, if Crystal stays at Wake Robin Drive, you'll have to find someplace else to stay until this case is resolved. In that event, you would be able to go by one time to collect your clothes, your toothbrush, whatever you need, wherever you plan to go. To do that, however, you would have to contact law enforcement first. They'd meet you there with a deputy. You'd have a few minutes to grab your things and get going where you're going. I'll have you back in court on this on the 19th of September. So like I said, I'm going to give the state 24 hours to come up with PC on the felony. If you're still here tomorrow, they'll bring you back to first appearance tomorrow, and we'll talk about it again. If you've bonded out, just make sure that you get to court on the 19th and that you go see the public defender right away, all right?
All right, thanks.
Thank you. We got these guys here? Okay. Austin Brady. Morning, Austin. You want to raise your right hand for me? Solemnly swear firm, tell truth, whole truth, nothing but the truth.
Yes, sir.
State your name.
Austin Brady.
All right. And what's your date of birth?
8199.
All right. So Austin, this morning we have some more warrants. The first one was signed by Judge Neal and contains a new count of burglary of a conveyance and a new grand theft. The second one also signed by Judge Neal, also another burglary of a conveyance and another grand theft. And the third one, also signed by Judge Neal, has 4 counts: burg conveyance, grand theft, principal to a burglary while armed, and principal to a grand theft. I believe you have the public defender on all your other charges. Is that right?
Yes, sir.
You want the public defender on these as well?
Yes, sir.
Okay. And Candace, so you signed these, so I'm guessing this is all part of the same course of conduct that they already have pending charges?
Yes, sir, but I would tell you the course of conduct is not one date, Judge. There are various offense dates.
Right.
And so,
Okay.
yes, all those charges, he's now 18, and
Right.
it happened just before he turned 18.
Right. But these are all charged as adult, right?
Yes, sir.
Right.
And he does have prior, as you know, prior juvenile history, failure to appears. So I'd ask that you maintain the bonds.
Right. And when are all his other cases set? Assume we want to keep them all in the same place. Maybe Christy can tell me that. Oh, you may have. I just hadn't gotten. Oh, there it is. Oh, yeah.
I thought it was
8:22.
today.
That's there
Okay.
today. That's why they're in the
Yeah.
building. Can I send them down with this stuff today, Candace?
I would think you should.
Yeah,
It would
so-
make it traditional economy and
So we-
get them all traveling together. That's-
Okay. Can do. He hasn't been to court yet, right, Randy? He hasn't been to court downstairs yet.
No, we're good right now.
Okay. All right. So, Austin, we're going to leave the bonds per the warrants on these then, which is going to be another 5, 10, 12, 14, 16, 18, $23,000, $48,000. We're going to attach these to the rest of your cases, which you'll be in court for this morning, and we can get busy starting to get these things resolved, all right?
I'm going to let, with your permission, Judge, I'm going to let the prosecutor know.
Yes, please do. All right. Thank you, Austin.
Mr. Brady, do you know who your lawyer is downstairs?
Ms.
Barbara Jo Bell.
Mr. Burgess, you want to come up? We'll, in between, we'll get him done. Davis, the time served, that's it.
Yes, sir, Your Honor.
All right. And David?
Oh, Mr. Burgess?
Yeah.
Yes. He, just pled out to, a DOC sentence and felony.
Okay.
Judge, he was given 10 years in DOC, although he has an extensive history. We know we want to get him to the Department of Corrections, so.
Right.
He has a lot of time. I believe it's 288 days. But they would have imposed the coin. Let me just check.
Downstairs. Yeah.
He's going to check. It will be a time served, but I think he's been in for a significant amount of time on this
Yeah,
case.
I knew it was, 228 days.
On this case?
Yes.
Yeah, he's been a long time. All right, David, raise your right hand.
This
please.
is this in M1 trespass or M2?
Yes, M1.
Okay.
Solemnly swear affirm tell the truth, whole truth, nothing but the truth.
Yes, sir.
State your name.
David Burgess.
All right, David, you understand by entering a plea today, you give up the right to have a trial by jury, the right to confront the witnesses against you, the right to remain silent, but you want to give up those rights so we can take care of this today.
Yes, sir.
Case number 17 MM 117. That's the charge of trespass. How do you wish to plead? You can plead no contest.
No contest.
Accept that plea, find it's freely and voluntarily made. Adjudicate you guilty of the charge, sentence you to 228 days, credit 228 served. Be a fine and court costs of $503, $100 for the public defender's office, but that takes care of your misdemeanor, David. You're now free to go wherever you got to go next, all right?
Yes, sir.
And that includes the cost prosecution, Your Honor?
Yes, ma'am.
Thank you.